There we go. With that, I will go ahead and turn it over to you, gentlemen. Thank you so much. We're looking forward to this.
Thank you for the great introduction, Chris. And hi, everyone. Hope you're all staying warm. I guess the folks outside of Ohio probably are doing that. Andrew, why don't you scroll ahead to the agenda slide since we've gone through the introduction. So we said 7 things on the slide, on the opening slide, and here are the 7 things. You'll see we have a lot of ground to cover. These are issues we run into on a day-to-day basis. What's going on outside in the US in terms of development of data protection law, dealing with medical information, employee monitoring, social media activity, data security, data breach. So these are all issues that Andrew and I deal with on a day-to-day basis. We're going to share with you a combination of what's going on in terms of legal developments and also our practical experience. Andrew and I will be switching off. We do have a lot of ground to cover. If you have questions, maybe you can note them. We're more than happy to take questions at the end. If we go over by a couple minutes, Andrew and I are both more than happy to stay on to respond to anyone's questions. And with that, let's dig into the presentation. Andrew, could you go to the first topic slide? So we're going to start with what is going on in terms of US data protection law. Could you go to the next slide? And what you will see on this map is really a development that has taken off since 2020, but really more 2021, 22, which is the start of what we refer to as comprehensive data protection laws. Until 2020, quote unquote, privacy law and data security law in the US was a combination of tort law and very specific privacy laws, laws like HIPAA that applied to medical information, or the Gramm-Leach-Bliley Act, which applies to financial information, the Fair Credit Reporting Act, which applies to background checks, and then state-specific laws. For example, Illinois' Biometric Information Privacy Act, which deals with, as the law would suggest, the collection of biometric data. The laws that are reflected in the color-coded map of the United States are what we call comprehensive data protection laws, and I'll go into more detail of what that means in a minute. The one point I do want to emphasize here, which I do think is very interesting, if you look at this map, the green states are the states that currently have these laws. There are 4. There are 9 yellow states that are about to have laws go into effect, and then about 8 or 9 blue states that have bills pending. But what is really amazing about this map is that you have the reddest states and the bluest states. Some of the blue states are green, some of the red states are yellow. But Indiana, Iowa on the one hand, Connecticut, California, Oregon on the other. So this is a nonpartisan issue. Nonetheless, the federal government can pass federal privacy law. So we have now a crazy quilt of state data protection laws. We're going to focus on California. It was the first one, and it will give you a taste of what these laws are about. Could you go to the next slide, Andrew? So the first question is, why do we call these laws comprehensive? And we call them comprehensive because they cover any individually identifiable information about an actual person, right? That's the definition of personal information. So the laws aren't necessarily going to be about privacy because, as you can see from the examples, some of the information on the slide is information you wouldn't consider private, such as an individual supervisor or an SSN, of course, but it could be travel information, the color of someone's car. That is personal information, and the law applies to every type of individual. So customers, employees, and employees, beneficiaries, emergency contacts, independent contractors. So very broad coverage. Next slide, please, Andrew. And the scope also is quite broad. So we talked first about the information that's covered. Now let's talk about the types of entities that are covered. So first of all, nonprofits are carved out. That's probably the biggest exception. Number two, because it is a state law, the law is going to apply only to businesses doing business in the state. So for those of you who are lawyers, and you go back and you remember from first year civil procedure, international shoe, and long arm jurisdiction. So it is possible that businesses outside of California that don't have employees or a physical presence in California could be subject to this law if they are sending products into the stream of commerce in California. But we most commonly see this, and given the size of California and the number of businesses there, with businesses that have employees and or physical presence in California. The other scope limitation is the size of the business, so annual revenue. Very small to small mid-sized businesses under $25 million in annual revenue are carved out. Now that $25 million could be revenue from anywhere in the world. It's not revenue from from California. Or if it's a smaller business and it's managing data, it's buying information, selling information, collecting a large amount of information, it will be covered with a threshold of 100K individuals, California residents. If you're collecting information, 25K California residents, if the business is selling. We go to the next slide. So now let's talk about the requirements of the law. And again, this is what I mean when we talk about comprehensive, not just the breadth of the information that is covered and the many categories of individuals who are covered, but also all of the different requirements that the law imposes. So the law starts with two notice requirements. One is a notice at collection. That's a smaller notice that needs to be given at or before the point where personal information is collected from an individual. It's going to include narrow information, the categories of information collected, the purposes for collection, the retention period, whether or not the information is sold. It's a prospective document. The bigger document is the online privacy policy, and that one is retrospective. It looks at the 12 months preceding the effective date of the policy, and it has to include not just the categories of information collected and the purposes of use, but the sources from which the information was collected, the third-party recipients, whether that be of a disclosure or of a sale, a description of individuals' rights under the CRPA and how to exercise those rights. So that's the second big picture point about this law. California residents have a set of data rights: a right to know, a right to delete, a right to correct, a right to opt out of the sale or sharing of their personal information, a right to non-discrimination. And but these rights, of course, are subject to exceptions and limitations. So, for example, an employee can submit a deletion request and said, my manager gave me a bad review, so I want it deleted. The information has to be inaccurate in order for the deletion right to attach. And then the last requirement is vendor management, that if the business shares personal information with the service provider, it has to enter into a contract with certain terms. Next slide. There are ideas of limiting the amount of data that's collected. That's data minimization, so only collecting the information needed for the purposes stated in the notice, and then not keeping it for too long. So there needs to be a defined retention period, and when that retention period expires, the data needs to be purged. There also are requirements for implementing reasonable and appropriate safeguards for the data, and we'll talk about data security in more detail later in the presentation, and training employees who are responsible for implementing the compliance program. So as you can see, businesses subject to this law have a lot to do to comply. Go ahead to the next slide, Andrew. Then we talked about how there are all these other laws coming online in 12 other states, and these laws are a little bit narrower than the California law. So they're only going to apply if the business collects a threshold amount of data, or the data about a threshold number of state residents. In most of these laws, that threshold is 100,000 individuals. Montana, smaller state, I think it's 50,000. And then, unlike California, none of these laws apply to HR data, which is a big difference for employers. But we're still seeing California is putting pressure on a lot of employers to roll out national policies, even though these other laws don't apply. Next slide. And then some of you might have heard about GDPR, which received a lot of press over the years. That's the European Union's kind of cutting edge, gold standard data protection law. And a lot of people will say, oh, well, are these state laws really the same as European law? There are similarities, but there are important differences. So, for example, for the California law, there are big categories of data that are carved out, like health information subject to HIPAA, background checks subject to the Fair Credit Reporting Act. Under GDPR, there are a list of reasons that businesses can handle personal information. And if one of those reasons doesn't apply, like consent or performance of a contract, it's illegal to use the data. There's nothing like that in US law. Same thing with disclosures. These laws do not restrict disclosure of information, whereas the GDPR regulates disclosures closely. And another very big difference is that US data laws do not put any restrictions on sending information abroad, whereas the European law makes it illegal to send data out of Europe unless certain steps are taken, or the receiving country has been approved as providing an adequate level of protection. So very quick overview, a lot to digest there, but more just so you all know what is going on in the US, what's coming down the pipe, and what it looks like. Andrew, let's go to the next topic.
Sorry, I was muted. Like Phil mentioned, there's some more niche data protection laws that govern things like medical information or other more specific types of information. So the second key thing to know is the ins and outs of the laws that do govern medical information and what rules might apply about keeping it confidential. And there's a number of different laws here that might come up in the employment context, all of which apply to medical information and varying different situations or different types of medical information specifically. So the first, oldest, and probably most well-known of these is the Health Insurance Portability and Accountability Act of 1996, or HIPAA. And kind of taking a bird's eye view of things, HIPAA really applies to any protected health information that comes from a covered entity. And so there's there's three different types of covered entities, two of which come up pretty regularly. One is a health plan, which in the employment context is a self-insured group health plan, like group medical, prescription drug, dental and vision plans, or a flex spending account, and a couple others mentioned here. And it's this way, which is how most employers can end up being subject to HIPAA, which is in their capacity as a sponsor of one of these health plans. But it doesn't quite include every employee benefits plan that a company provides, and HIPAA does not cover things like workers' comp, disability insurance, or stopgap insurance. And it gets a bit into the weeds, but it kind of hinges on whether it's the plan is also covered by ERISA. But it's worth knowing that HIPAA applies to many, but not all employee benefits plans. The second kind of covered entity that's relevant here is a healthcare provider. And this is most healthcare and medical providers, so long as they use HIPAA's electronic billing codes. Because as kind of a weird quirk, HIPAA wasn't originally really passed as a data protection law. It was enacted by Congress to kind of force the healthcare industry into standardizing the way that they bill for their services and using one uniform set of billing codes. And kind of as an afterthought, Congress added one paragraph about keeping that data confidential and secure. And the Department of Health and Human Services kind of ran with that and issued 50 pages of regulations that are now known as, what most people see as HIPAA. But in that respect, the medical providers and healthcare providers that do not use those electronic billing codes would not be subject to HIPAA, even though most of them do in reality. And so HIPAA then applies to any protected health information, or PHI, that's created or received by one of those covered entities. And it's a common misconception that this is really every piece of medical information out there, but really it doesn't have to directly relate to medical information. And it's not every piece of medical information. First, it needs to be identifiable, which obviously can mean, the person's name is attached, but it can also be some other sort of identifier that lets you narrow down who the information is speaking about. And it also has to generally relate to the condition or care or payment for care of an individual. So the fact that I went to go and eat at a hospital cafeteria isn't PHI, even though the hospital is a covered entity, because it doesn't relate to the condition or care of an individual. And the same is true with employment records of a covered entity, because those don't relate to the condition or care of an individual. And so that's kind of how there's a bit of a firewall there between an employer in its capacity as an employer and all of those records, including certain medical information, and an employer acting as a plan sponsor of one of these covered health plans, in which case all of the protected health information that relates to those plans is covered by HIPAA. And so once you're looking at whether you can have PHI in the employment context, HIPAA really dictates the when, why, and how you can disclose it. And the general rule here is that the individual, like an employee, if it's their PHI, has to give their authorization for the disclosure of that information using a form that complies with HIPAA's requirements. But there's a number of exceptions to that, as you might realize, and we haven't covered them all here, but the first common point we see is when a union might request PHI, like enrollment data for a health plan, claims information, or in the context of investigating employee discipline. And there's a couple ways that there can be a lawful disclosure of that information. First, like I mentioned, is always going to be when the individual gives their authorization. But another exception is disclosures for TPO purposes, or treatment, payment, or healthcare operations, which doesn't need an authorization And the healthcare operations portion of that includes resolution of internal grievances, which might be negotiation about the scope of medical and benefits coverage by an employer. But it's worth mentioning here that that is a permissive disclosure, not mandatory. So an employer really has discretion over whether the union's justification for seeking that PHI is good enough, so to speak. And then the second exception that would apply here is when the information is de-identified, which kind of makes it lose its status as PHI entirely. And that's when the information is stripped of that identifies it to an individual, like you remove their names or any other specific identifiers like address and a number of other things. And so if a union needs sort of aggregated information like total enrollment numbers or the average amount of claims made, an employer is really free to disclose that information without any restrictions, so long as they remove those identifiers and keep it de-identified, so to speak. And then outside of the union context, there's some other rules that apply that we commonly see. Most notably, business associates, meaning service providers that have agreed to HIPAA's vendor contracting terms, can receive PHI. And then, of course, as required by law or when helping law enforcement with an investigation, that's also something that doesn't require the individual's consent. And so when an employer receives health information for employment purposes, rather than administering one of those covered health plans, the health information is not covered by HIPAA, but both the ADA and FMLA can come into play, and they each have their own requirements. The ADA's confidentiality provisions can apply regardless of whether the person's disabled, and they can come up by limiting the types of medical exams and disability and related information that an employer can inquire about. And then the FMLA obviously comes up with certain documents like medical histories and records provided when an employee goes on leave. But sometimes there's an overlap between the FMLA and ADA where, a medical exam can kind of be covered under both laws. And so when it comes to disclosing that sort of information that's covered by one of these laws, the main thing to keep in mind is that when the ADA applies and it relates to a medical exam or disability-related information, that information can only be disclosed in a limited number of circumstances, like to managers with a need to know, or to implement accommodations, or first aid personnel for emergencies. But otherwise, it needs to be limited to only the employees with a legitimate need to know that information. And finally, the Genetic Information Non-Discrimination Act, or GINA, might come up for employers. And in the employment context, this really piggybacks off of the AD and FMLA a bit, because there's really almost never a situation where an employer can directly request genetic information about employees, but a company might receive that as it relates to a medical exam under the ADA or documents covered in the FMLA. So in short, an employer can't discriminate based on this information, which came up in the past quite a bit when an employer might realize that, say, a certain employee had a risk of cancer and might cost them a lot in health insurance premiums. But then when it comes to disclosing this sort of information, the same sort of confidentiality rules apply as they do for the ADA and FMLA. And so you need to keep that in account when kind of comparing general medical information confidentiality to the more specific rules that apply with the ADA, and then of course with HIPAA. And then I'll move on to the third piece here for Phil.
All right, thanks, Andrew. So let's go to the next slide. And look, in today's world, we all know the intersection between work and social media activity is inevitable. And a lot of times employees who are faced with discipline all of a sudden become card-carrying members of the ACLU and say, hold it a second, I have First Amendment rights. You can't fire me based on my social media activity. And what most employees don't recognize is that the First Amendment does not restrict private employers' ability to fire employees based on their social media activity. Only public employers, only the government is limited by the First Amendment. Now, there are some statutes that protect employees' lawful off-duty conduct. For example, Connecticut does have a state law that extends the First Amendment to private entities, but it's only a handful of states, and these laws are fairly narrow. So, for example, off-duty conduct that constitutes a conflict of interest with the employer loses protection under these laws. So there are not a lot of employees who are going to be able to rely on these laws. And even when these laws come into play, there's likely an exception which will not, or which will allow the employer to discipline. Let's go to the next slide. Another issue is access to social media. So publicly available social media is fair game. Now, more than a majority of states have what we refer to as social media password protection laws. And these laws generally prohibit employers from gaining access to employees' personal online account. I should say employees or applicants. So the laws will prohibit employers from requesting login credentials for an account or shoulder surfing, or requiring an applicant or employee to accept a friend request. Now, what's interesting is, I've been advising clients on social media issues for probably 15 years now, and I have not ever really had to analyze one of these laws to see whether what one of our employer clients wanted to do complied with the law. As a practical matter, employers don't want to go there. Yeah, every once in a while, an employee or manager who will have been friended will see something in a restricted social media account and will volunteer it to HR. And that's fair game. These laws don't apply to that. But it's rare that employers will try to bypass employees' restrictions on their social media conduct. But where the big protection is the National Labor Relations Act. Section 7, which, as many of you know, protects employees, both unionized and non-unionized, against discipline for quote-unquote protected concerted activity. There's some examples on the slide. And this is a very broad protection, particularly because one of the things a lot of employees talk about in social media is work. The challenge for employers is you put 7 labor lawyers in a room and ask them if a particular fact pattern constitutes protected concerted activity, and you'll get at least 3 different answers, maybe 7 different answers. So it can be challenging for employers to discern whether or not social media activity falls within the scope of the act. One rule of thumb I tend to use is we versus I. And these are some examples where things can get tough. And things are only going to get tougher this year for employers because of the presidential election. We saw this in 2016. We saw it in 2020. There's going to be a lot of nasty social media content out there. And there are many non-employees who will out an employer's workforce, send, for example, this, what you see on the slide here, send a message to a business saying, I can't believe you employ this racist, you should fire the guy. And employers need to grapple with some very difficult situations to decide, is the social media activity protected? And even if it's not protected, do they want to draw a line? Do they want to regulate that off-duty conduct? Next slide, Andrew. The last big picture point about social media is the policy. So we've been talking about specific conduct, but separately, the board in August issued this opinion, Stericycle, which overruled prior Trump-era law, the Boeing decision, and set a very difficult standard for employers to meet, and whether to prove that their workplace policies do not kill Section 7 activity and violate the NLRA. And here are the factors, but basically the board is going to look at what would a reasonable employee think of this policy language, and it's the employee who wants to engage in the conduct, is worried about getting fired if she does engage in the conduct, is reading the policy as a layperson, and is economically dependent on the employer. Now stop for 1 second and think about that. For all of you who are arbitrators in the room and who are lawyers, according to this standard, you are not able to construe an employer policy because you're a lawyer. And these policies need to be construed from the perspective of an economically dependent layperson. So I'm not sure how exactly this is going to play out. We haven't seen cases follow this. I mean, the question is, do you need testimony from non-lawyer employees about their understanding of the policy in order to apply this standard? So it's going to be interesting to see how it all plays out, and keep an eye on what the board does over the next year. Andrew, why don't you take it to the next topic?
So looking a bit more broadly, then social media monitoring is really all electronic monitoring in the workplace, and what sort of rules an employer has to abide by when putting certain types of new technologies into place. And of course, there's no one-size-fits-all approach when it comes to employee monitoring and what employers need to be thinking about, but there's some overlap here on the issues. And over the last few years, we've seen employers implement quite a bit of these types of monitoring, especially biometric time clocks, location tracking, and different types of monitoring on employees' computers or cell phones. And so when it comes to what employers need to be thinking about for each of these types of monitoring, I hate to give the classic lawyer answer of it depends, but each of these should at least trigger a flag for you that some additional type of compliance measures might be needed. And so looking at location tracking as an example, a number of different states have statutes that govern vehicle location tracking, or tracking a person generally, or tracking in the workplace. And depending on what technology an employer might use, this might trigger one or more of these laws. For example, a telematics or drive vehicle camera might trigger those vehicle tracking statutes, but not the others. And generally speaking, though, location tracking is something that an employee has a reasonable expectation of privacy about and has some degree of common law rights about, especially when it comes to tracking over long periods of time, like the Supreme Court has found in the law enforcement context, but which lower courts have taken and applied in decisions to private employers. So it's also worth thinking about with regards to how the tracking works, whether it's constant or whether it's something like geofencing that can only tell when someone is inside or outside of a certain area. But like I mentioned, though, there's some overlap here for any type of monitoring. And the main thing is that employees really need to be informed, at least to some degree, that there's monitoring taking place. And depending on the type of monitoring and what jurisdictions you're in, that may involve a more robust sort of notice that gives them detail about what and why a certain technology is being used and what purpose it's being used for, as well as obtaining consent for that monitoring. But then in practice, companies should be aware that monitoring can really encompass quite a lot of data and end up over collecting certain amounts of information. And so when implementing these sort of technologies, it needs to be carefully tailored and structured to only monitor things that are, based on a legitimate purpose, and make sure you're not over collecting data like locations of employees 24 hours a day or when they're on meal or rest breaks versus during working time. And then, of course, especially for those more invasive types of monitoring like location tracking or biometric data, it might justify either a more detailed notice, like I mentioned, or it might be a mandatory subject of bargaining, depending on what a CBA already covers. And so on a similar note, and going back to a more specific type of monitoring, one of the issues we see come up all the time in the workplace, sometimes alongside these other types of electronic monitoring, is recordings and wiretapping specifically. And there's some specific quirks here that make this type of information a little bit different. So generally speaking, every state has some type of wiretapping or eavesdropping law. And a lot of these are similar to the Federal Wiretap Act, which prohibits an interception of any wire, electronic, or oral conversation. Wire generally meaning phone, oral meaning in person, and electronic meaning online. And in general, the requirement here is that at least one party to the conversation needs to consent to that recording or that interception. But some states require the consent of all parties. And it's important here because what if I am having a conversation with a coworker in California and need to know whether I need the consent of all parties or just of myself to record that conversation. And at least among California courts, they've found that the law can apply interstate. So it's really everyone and employers included that should be on the lookout and really err on the side of thinking that a stricter law applies when you're dealing with recordings that cross state boundaries. And this is all important because these laws are pretty high risk, both, of course, in terms of criminal liability, but they also carry pretty steep statutory penalties, including very high damages for each individual recording that's done without consent. And so, like I mentioned, these laws apply to wire, oral, or electronic communications. But this really boils down to any sort of real-time recording or collection of data that might capture the content of a conversation. So it also covers the sort of activity monitoring and data loss prevention software, screenshot capturing and keystroke monitoring, and then tracking or recording instant messages or even company-related emails, and of course, personal emails as well. And these wiretapping and recording laws aren't just an issue for actually taking the recording or conducting the interception itself, because even if someone else takes the recording, you or an employer risk a separate violation of these laws if you use or disclose the recording or otherwise rely on it knowing that it's in violation of one of these laws and consent wasn't properly obtained. And then, of course, every state restricts how these can be used in evidence, since it's kind of a fruit of the poisonous tree issue here, if you remember that from criminal law and law school. And there's really only very limited exceptions to this that don't commonly come up, like using it as evidence to prove that a wiretap law was violated. And so when looking at recordings in the workplace that implicate these sort of laws, the main consideration here is obtaining the proper degree of consent. And fortunately, this can be either explicit, like written consent, or implied, meaning like we've done with this call recording here, which is as long as you know that it's being recorded and you've stayed on the call, you've consented to recording. But similar to those other wiretapping law or those other electronic monitoring laws, you should be cautious here to make sure that you have the proper degree of notice and consent before the recording takes place or before you rely on that data, and make sure that you're exercising caution when it comes to over collecting certain information. And those same sort of employee protection, protected activity considerations that Phil mentioned earlier with social media apply here. And there's really very limited situations where an employer, even thinking that, hey, these laws are high risk, why not just ban recordings altogether, there's very limited situations in which an employer can do that, even when it is only a policy that says you cannot record in violation of one of these wiretapping laws. And so either with electronic monitoring as a whole, or especially with the kind of recordings or eavesdropping laws in the first place, employers and employees should be cautious about when they take place and when and what circumstances you're using the kind of recording or information gathered from these. And I'll go back to Phil here.
Thanks, Andrew. So up until now, our first 5 topics have focused on privacy. We're going to switch gears and talk about data security. So let's go to the next slide, and we have another map. And what we are seeing is across the US, a majority of states, or near majority of states, has some type of law regulating information security. For most states, the requirement is very high level, such as a data owner has to implement reasonable and appropriate physical, technical, and administrative safeguards for personal information. Other states have more detailed requirement. New York, for example, has a law called the SHIELD Act, which lays out about 10 different steps businesses need to take. And if they take those steps, they will be presumed to have in place reasonable safeguards. Massachusetts has regulations that lay out very specific steps. But I think in general, both lawmakers and regulators don't know much about information security. They're not IT people, they're not IS people. And so they're nervous about getting too deep into the weeds and implementing or enacting very detailed standards. Can you go to the next slide? But what we are seeing is a general consensus around the types of steps that should be considered reasonable. So, for example, on administrative safeguards, having policies around information security, controlling access to information, both at inception, so figuring out who is authorized, and then even after someone's authorized, either terminating their authorization completely if they leave your employment, or modifying their access rights if their job changes. Physical safeguards can be anything from video cameras in a server room to a clean desk policy to simply having locked file cabinets for paper files that have sensitive information. The technical safeguards tend to be more for information security, encryption, password protection, malware protection, firewalls. That's kind of what we're talking about. We're not doing a deep dive here on what each of these are. I just want to give you a flavor, some examples. If any of you have any concerns for your own business and how your business is maintaining information, the Federal Trade Commission actually has an excellent webpage on this. So you should click this link, or you'll find it in a PDF, and you'll find some great tips. Can you go to the next slide, Andrew? Now, I know non-IT people, non-IS people, lawyers who are not practicing in this area thinking, this is not my problem. It is, because keep in mind, insiders, individuals are among the most significant cause of data breaches. And Andrew will talk about this more in a minute. And there are some very simple steps that most businesses can take to reduce risk to their information. So, for example, running background checks on people, and for those who are going to have regular access to sensitive data, really digging into those background check results to see if any prior criminal history raises an inference that the individual might not be trustworthy with sensitive data. Requiring employees to sign a confidentiality agreement, making sure that they receive training. Let me see if I could see the slide and remind myself of other things. Bear with me 1 second. Personal devices, that is a real risk area. We're seeing more and more clients allowing employees to use personal devices for work. It creates a real risk when the device is lost or stolen. So thinking through what type of technology can be required before an employee or a contractor is permitted to use a personal device for work. And then offboarding. It's much easier to get equipment back from employees before they're told they're fired, or on their last day when they still can be told to show up at a physical office, particularly with our remote workforce, trying to get a laptop back, even if the employee is not disgruntled but is not coming regularly into work, can be a real challenge. So thinking through that offboarding process is important. Go ahead, Andrew. Training as well, making sure particularly that employees with responsibilities for safeguarding information or for handling sensitive information regularly receive both onboarding training, annual training, and security awareness reminders over time. And those trainings should address things like, what are the organization's policies? What should the employee do if he or she learns about a data breach or a security incident? To whom should it be reported? What do you do when you want to share information with a service provider, outsource a function? What steps need to be taken? And let's talk about that, Andrew, as a final closing point on this general topic of information security, and that is vendor contracting. And what we see here is in the last 5 to 10 years, cloud service providers have become a critical part of all businesses, especially for HR administration, but also for managing customers. Salesforce, for example, so many businesses rely on Salesforce that have millions of individuals' data. And so what's happened is that these service providers are like honeypots for hackers. They are looking to get into the honeypot and steal large quantities of data at one time. And that means for the customers, for your business, for the employers, they need to make sure that they are protected. And that means first vetting vendors before sending them data to make sure they have robust information security programs, and then contracting with the vendor on data protection, on data security, to allocate risk and to ensure that the service provider will not use the information received from or on behalf of the customer or the employer for any reason other than providing the services. Will implement the same types of safeguards for information that the customer has to implement, making sure that if the service provider uses a subcontractor, that the service provider is contractually bound to flow down those obligations to the subcontractor, and maybe most importantly, having indemnification from third-party claims if the service provider has a breach, and also an expense reimbursement requirement for a first-party claim. In other words, that the customer itself could incur significant expense responding to a data breach at the service provider without a third-party claim ever arising. Now, making sure the service provider has adequate assets if there is litigation and cyber risk insurance. So it really is taking the same type of holistic approach to data security that we're seeing in terms of data privacy. Andrew, why don't you close out with what happens when things go south?
Yeah, and so our final point here is really the answer to the question of what happens when you don't have those safeguards Phil talked about in place, or even what happens when a vendor doesn't have those safeguards in place. And I'm sure you've all heard quite a bit about data breaches, either in the news or maybe you've even gotten some letters or emails from different companies saying that your information has been exposed. Since, as you can see here, about 100 million Americans or so over this past year received a breach notification letter, and things are only increasing as the kind of market value of this data has increased year over year as well. And it's an important point for employers because in most circumstances, an employer is going to store tons of sensitive data about their employees, probably more than any other company. And most data breaches end up being triggered by a human in some shape or form, including employees, whether it's intentional or not. And it's usually based on some degree of either inadvertence or lack of safeguards in place to protect against those mistakes or malfeasance. And so it's obviously important because data breaches can be quite a bit more complex and expensive than people realize. Of course, in terms of direct costs, the average cost of a data breach this year was about a little over $4 million. But there's some hidden costs that you might not think of, like reputation loss, lack of goodwill, or even losing trust from your employees when the incident involves employment data. So if you remember back to about 2019 with Equifax, they're not exactly a company that everyone in the US loves today for a pretty good reason. But also in terms of responding to these breaches, it can end up being quite a bit more complex and time consuming than one might think. And it really, even on average takes nearly a year, and that ends up being a cost center in and amongst itself through legal fees, service provider costs, and that kind of ongoing business loss or just unavailability of systems if there's some sort of situation involving hacking or some other type of technical safeguards that are exposed. And so there are obviously some other types of breaches too, like ransomware and hacking, like I mentioned, but the ones we've mentioned here we see come up pretty commonly in the employment context, and these are really those employee-caused or human-caused incidents that are really the most common, like inadvertently emailing a spreadsheet with social security numbers, or an employee isn't properly trained and they end up falling for a phishing scam, as I'm sure you've all seen. And for each of these, the things really boil down to not having those administrative, physical, or technical safeguards in place for personal information, or not keeping them updated enough to really track the most common incidents that occur year over year. And so once you've identified something that might be a data breach, when it comes to responding, the first thing to look at is what laws might apply. And even if you are a company who has employees only in Ohio or only in a certain state, this really depends on where the individuals themselves reside, and not where the company is located or where the incident actually occurs. And so particularly with respect to customer information, there are many times where even though a company only operates mainly in one state, a data breach can involve all 50 different state laws, as well as Puerto Rico, DC, and Guam, as well as any international laws that might come into play. And so then each state law kind of varies on what they consider to be personal information or trigger data, meaning the information that triggers this sort of application of these laws. And in every state, somewhat obviously, it's social security number, driver's license or state ID number, and a credit or debit card number, along with some sort of code or expiration date or other password that might allow someone to make a payment on those cards or charge something to those cards. But a number of states have any sort of outliers. For example, medical records or health insurance information, biometric data, or even an email username and password can be considered personal information that triggers these laws in some states. And then ultimately, all of these laws are really consumer protection laws that are meant to help people prevent identity theft and fraud. And so a number of these states have kind of realized that and have exceptions for when there's no real risk of harm, like if data is exposed and immediately deleted, or if it's almost certainly not going to cause some degree of identity theft or fraud. But other states can be more strict and might require notice anyways. And finally, this is a bit fact specific, but in the context of a data breach, employers should consider what sort of steps have been and can be taken in response. And partly this stems back to that legal requirement of reasonable safeguards for personal information to kind of prevent data breaches from occurring. But it's also an employee relations issue, since you'll be telling employees or customers what happened, and you want to ensure that they know that the company takes this seriously. So this, depending on what occurred, this might involve training, working with IT on new technical measures, updated policies, or any number of other things. And so once you've kind of done that initial analysis and analyzed whether a breach has occurred, you need to look at what all of these different state laws might require. And of course, again, there's sort of a patchwork of different requirements across all 50 states. But one thing that's almost universal is notifying the individuals impacted, whether it's employees, customers, what have you. And then also it might involve notifying a state authority or regulatory authority like HHS, although usually under state laws that is the Attorney General. And these are either triggered automatically or when a certain number of state residents are impacted. For example, here in Texas, if over 250 people are impacted in Texas, you will need to notify the Texas AG. And then in certain circumstances, some of these laws require that alongside that notice to those impacted individuals, they take a more proactive approach to mitigation and offer some type of credit monitoring like LifeLock to those impacted individuals. And I'm sure all of this seems extremely straightforward. There's obviously some overlap here on the different legal requirements, but it can really be a time crunch when you're dealing with these situations and trying to analyze all of the issues involved. When a lot of these laws either can sometimes have a more nebulous requirement, like without unreasonable delay or as soon as practicable, but other laws have 30-day deadlines, 60-day deadlines, or even for international laws as short as 72 hours, like the GDPR that Phil mentioned. And we've seen a lot of cases where just the step of finding out who are the impacted individuals and what's their address can take well over 30 days. And so timing is always a consideration in these sorts of issues, particularly when you're notifying those state authorities and they're regularly coming back to make sure that the company didn't delay in notifying and didn't dawdle when it comes to investigating and responding to these data breaches. And so going back to that one final safeguard that Phil mentioned, there's those sort of vendor contracting requirements come up a lot when it's a vendor who falls victim to a data breach rather than a company. And so the analysis here changes a bit, but it's important to note that under all of these laws, the company as the data owner is really holds the ultimate responsibility and liability for notifying individuals and notifying different state authorities in the event of a data breach, even when it occurs with a vendor. And so in some of these situations, companies might elect to handle the work themselves, in which case the same sort of analysis applies. And in others, they might take a more supervisory role of sort of overseeing the vendor's own response to a breach. But it's important to make sure that those responsibilities are clear and to take a close watch at what a vendor is doing, because in a lot of cases, like for those service providers like Phil mentioned that might have huge amounts of data for any number of different customers, they could be dealing with more information than just your company's, and they might be trying to take a more efficient, so to speak, approach or cost-efficient approach that might not put as much care into notices or providing detail to individuals that an employer might want to give. And so even then, there are steps that a company will want to do proactively, even when a vendor is handling most of this response, like giving some advance warning that a vendor has been subject to one of these breaches, because sometimes employees might not even know who a vendor is and why they have their personal information. But all of those costs of a data breach I talked about can still impact an employer when a vendor has a breach, including those legal fees as well as reputation and goodwill. So ideally, you're already going to have these contracts in place with vendors so you can request that reimbursement indemnification. But of course, if not, it's going to be a pretty quick lesson learned, even after only one of those things, about wanting to renegotiate those contracts in the future and making sure that to the extent it might come up later on, you have those safeguards in place and you're ready for anything that may come up. But with that said, that's kind of all the 7 pieces we wanted to cover with you. If anyone has any questions, or Phil, you have any final points you'd like to add?
Thanks, Andrew. No, I know we're a couple minutes over time, so thanks everybody for your attendance and attention. Our email addresses are in the presentation on the slide with our photos. Feel free to use those if you have follow-up questions. Andrew and I are more than happy to stay on. I'm sure many of you have other commitments, but if anyone does have a question that they want to ask now, we're more than happy to stay on if that's okay with Chris.
Absolutely. Absolutely. Any questions from our attendees? I do have to say that was an amazing presentation. That's definitely a very interesting topic for a lot of us. I know we all really enjoyed it today. I don't know if you're seeing it in the chat log, but you've gotten several thank yous, great presentation. And I have provided a copy of that presentation PDF format in the chat log. I will also send it out to you guys via email when I send you the link for the survey. So like they said, please use that. Please feel free to take a look at that. And if you have follow-up questions, like they said, they have included their email addresses. So an amazing resource. Thank you so much, guys. This was a great presentation. We really appreciate it. Any questions from anybody?
Thank you. Thank you, Chris.
Thank you.
If no questions, we hope everybody else enjoyed attending the event today. Like I just said, we will be sending out a survey. It will have the link not only for the survey, but also of the presentation as an attached file. And our next presentation is going to be on February 20th. That one will be our next in-person event, unless there is some sort of weather issue that arises. So that will be an in-person event, and it will be located at our state library, which is 274 East First Avenue. Again, the state library at 274 East First Avenue, where we will have Dan Gutman and Chris Hogan speaking on collective bargaining rights in our universities. So thank you again for attending today's event. We hope you enjoyed. And a huge thanks again to our speakers. Thank you, guys.
Thank you, everyone.
Thank
Have
you.
a great day.
You too.